Good morning and welcome to the DC Court of Appeals. As a general reminder, we ask that you mute your cell phones at this time so as not to disturb this morning's arguments. Thank you. We'll be starting shortly. All rise. All persons that have business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please be seated.
Good morning, everybody. Welcome to the District of Columbia Court of Appeals. You will see we're a little short-staffed this morning. Judge Beckwith is feeling a little bit ill and she's going to be taking the argument on the tapes. We'll begin today with our first argument, District of Columbia versus Amazon. Ms. Van Zyl, whenever you're ready.
Good morning, Your Honors, and may it please the court. Caroline Van Zyl on behalf of the District of Columbia. I would like to reserve 2 minutes for rebuttal. Over 2 years ago, the district filed a complaint alleging that Amazon entered into agreements that effectively inflated prices across the internet. We allege not only that the agreements were express and written, but also that Amazon sellers were routinely raising prices on other platforms and their own websites as a result of those agreements. Cases alleging express written agreements and concrete market-wide allegations of raised prices are rare in antitrust law and should be simple, at least on a motion to dismiss. Indeed, 4 other courts have examined these same agreements and found them to be plausibly anti-competitive. The FTC and over a dozen states agree and have filed their own case. Even the Department of Justice has weighed in here. Yet the trial court in this case made the district the sole outlier in this respect by disregarding our concrete allegations that Amazon charges higher fees than competing marketplaces like Walmart and eBay, and then forces sellers to incorporate those high fees, what I'll call an Amazon tax, in all of its other listings.
Let me ask you to clear up something for me at the outset. A couple of the amici at least argue that the district does not think it has to allege plausibly an anti-competitive effect of the agreement. Do you agree that the plausibility standard of Twombly and Iqbal applies to the anti-competitive prong of these allegations?
Of course, we agree that the plausibility standard applies to that prong of the Section 1 test. Our only contention is that the analysis, the antitrust analysis in Twombly itself, which dealt with the first requirement of a Section 1 claim with the formation of an actual agreement, that language specific to that prong doesn't apply. But otherwise, of course, the plausibility standard applies. We've never contested otherwise.
So
And
let's talk a bit, if we may, about how one would allege that when there is an actual agreement. So the agreement is there. How does one allege the anti-competitive effect?
well, you can allege
And
anti-competitive.
Let me offer a couple of options. One way would be if the agreement is poorly drafted and it commits everybody to fixing prices. We don't have that here. You agree?
Well, we do have an agreement that does place a constraint on prices, but I will grant you that it says prices can't be significantly higher on Amazon, meaning they can't be significantly
Other
lower
options
elsewhere.
might be you have an agreement. And then we have to think about what are the logical inferences to be drawn from that agreement. Another possibility is this may look like a benign agreement, but let's see how it plays out in practice. How are you meeting the standard of plausible allegations?
Sure. Well, I would put it in slightly different terms. There are three different ways we can show anti-competitive effects. Under the rule of reason, there's direct evidence, there's an indirect way of proving anti-competitive effects, and then there's under a per se theory. So I think the easiest way to go here is just direct effects. And you are absolutely right that if an agreement wasn't intended as anti-competitive, if Amazon was absolutely correct that in its heart of hearts, it believed it would lower prices, but it does in fact have anti-competitive effects that are caused by the agreement itself, that is enough to plausibly plead anti-competitive effects under the second prong. And we think that we've done that in several ways. I mean, we have alleged at JA18 that third-party sellers regularly increase their prices on other online marketplaces to avoid sanctions that Amazon places on them. We've alleged at JA31 that Walmart.com routinely fields requests from sellers to raise prices on Walmart's online marketplace because sellers worry that a lower price on Walmart's online marketplace will jeopardize their status on Amazon's marketplace. So not only do you have allegations that many sellers are in fact raising their prices on these competing platforms, you have an allegation of a direct link to the agreement. So even if we thought the agreement was somehow ambiguous, I don't think that there's any serious contention here that the anti-competitive effects are flowing directly from that agreement.
Can we take the agreement out of it for a second? And what would you still have a suit if there were no agreement between Amazon and third-party sellers, but only enforcement? What if Amazon said, in a consumer-facing advertisement, we guarantee you the consumer, you're not going to beat our prices. And when they have sellers on their platform that end up offering their products on a third-party platform for less, Amazon then sanctions them. There's no prior agreement going into it. What then?
Well, we think that there would still be concerted action there and potential anti-competitive conduct. And in particular, we think that that would be on all fours with the Monsanto case. which Amazon itself cites multiple times. In that case, you had Monsanto as a product manufacturer interacting with its distributors who are out there selling in the marketplace. And although there was no express written agreement, Monsanto had in effect set a minimum resale price. And what you saw there was whenever a distributor went below the minimum resale price, there would be consequences. Monsanto would talk to their parent company, would threaten to cut their supply, would essentially threaten consequences that are not entirely dissimilar from the consequences that Amazon has threatened here. And because of that back and forth and the effect that it had on the market, it was held that that was absolutely concerted action. And as you point out, Your Honor, it's a much weaker case than this, because here we do in fact have the express written agreements. We just have.
But you know, the reason why I asked the question is because the express written agreements are not quite what you're alleging are being enforced, right? The express written agreements, at least as of 2019, provide that you can't charge significantly higher significantly higher prices on Amazon versus other platforms. Now, the enforcement effects that you're alleging are something quite different, that you can't offer higher prices on Amazon, period. So in a way, you could see that as a sort of extra agreement, unilateral action on the part of Amazon. They're doing something more than they've ever agreed to with those third-party sellers. They're saying, you know, unilaterally speaking, we're just not going to let people on our website who are selling for higher prices to Amazon customers than to anybody else. I mean, I take your answer to be that's still concerted action because by virtue of continuing to sell on the Amazon website, you've sort of, with that understanding, you are acting in concert with Amazon. Is that, but that's not an express agreement though, if that were the factual scenario.
Well, I mean, we actually do think that this back and forth is tethered to the express written agreement. As you point out, Your Honor, even if it weren't, we still think that there could be liability. But in terms of what you need to link the conduct to the agreement, it's really just a causal relationship. It doesn't have to be, the anti-competitive conduct doesn't have to be described down to the tiniest detail by the written agreement for there to be that kind of relationship. And I would just quote from ZF Meridor, the approach we think is right here is that courts must look past the terms of the contract to ascertain the relationship between the parties and the effect of the agreement in the real world. And as you know, we have alleged the effects of this agreement in the real world in spades. We allege that if Amazon catches a seller offering the same or a similar product through another online marketplace at a lower price, not just a significantly lower price, any lower price. Sanctions can include all sorts of things from cancellation of listings, losing the buy box, to being kicked off of Amazon. Indeed, sellers in Amazon invest in this very expensive scraping software to canvass other sites online to make sure they know the second that their price drops on another website. And then we also allege that sellers report regularly receiving alerts that they are being sanctioned because they were selling the same or similar product through another online marketplace at a lower price. And because we have alleged those effects, we think that's enough under the second prong. Now, one other thing that you spoke to is unilateral conduct, and I would like to address that because the word unilateral is used here and there in Amazon's brief. We don't think that they actually make an argument that this is unilateral conduct. We think that that was forfeited. They don't really seem to contest that there's an agreement here. I read their brief as contesting principally whether it had anti-competitive effects. But even if that claim had been preserved, I would turn back to Monsanto to say that the conduct here couldn't possibly be unilateral. Maybe when you have a written agreement, it can sometimes be unilateral if it's a very take it or leave it sort of thing. If a seller is selling a product that comes with terms and conditions, that's not what we have here. What we have here is an intermediary, this sort of agent of these sellers, coming to an agreement with the sellers about what the sellers will do on other platforms. So this can't be unilateral conduct by Amazon because it very much involves the third parties, even if it involves them unwillingly. They are the ones going out, raising their prices on other platforms. And we would just submit that there's no case that would call that unilateral conduct.
Let me ask you about the previous agreement, I think it was called the price parity agreement.
Correct.
Is that part of your complaint, or is that just sort of background and context?
Oh, it is part of our complaint, and we do
But,
think.
if it is no longer in existence, what relief are you asking with respect to that agreement?
That would be damages relief only. I would concede, Your Honor, that we couldn't get injunctive relief as to the PPP, as we call it, but we do think that it is still part of this case. It still could be considered at the damages stage or even as part of the anti-competitive course of conduct when a court is formulating a more structural remedy. That said, it does also provide helpful background in that the fair pricing policy is enforced and interpreted in exactly the same way as the price parity provision. And
Let me ask you about Judge Puiglogo's ruling. As I understand his ruling, and perhaps he didn't articulate it in quite this way, I think he's concerned it's easy to allege things. Give me more concrete facts. I want to make sure that you're not just making all this up to try to get the poor defendant into expensive discovery and force a settlement. He would, I think, have been more comfortable if you put names and dates and prices in your first amended complaint. Why isn't that a reasonable requirement under Twombly?
well, it's not a reasonable requirement under Twombly because Twombly made very clear that antitrust cases are not subject to a heightened pleading standard. We're not required to act under Rule 9 and plead fraud here. It is enough that we allege facts that taken as true would make it to be plausible that we are entitled to relief. And I'm not aware of any case out there that says that someone other than the defendant who is named in the or who is implicated in the allegations in the complaint has to be expressly named. And as our amici from the committee to support the antitrust laws say, there are a lot of reasons why the names of sellers might not appear in these complaints, even when they're quoted in other complaints. Often the identities of the sellers are kept anonymous because what we've alleged here.
That's a really evanescent argument, isn't it? Sooner or later, and probably sooner, when discovery begins, you're going to have to start identifying these people. So if we're worried about the chilling effect on them, that doesn't really get you too far along in the litigation.
Well, that may well be true, Your Honor, but it doesn't create a requirement that we name these folks in our complaint. And in a way, it seems quite backwards to say that because we have alleged that many sellers have engaged in this conduct, that we somehow fall short because we haven't picked one out to use as an example. Could we have done that? Sure. Have other complaints done that here and there? They have. Is it a requirement? Absolutely not. And particularly where, Rule 11 does apply, I think, and the law says outright that when we make factual allegations in our complaint, they are to be taken as true. They're not to be second guessed because we're not forecasting the exact evidence that we want to put on at trial. There are all sorts of reasons why we might not do that in advance of summary judgment. All sorts of reasons, from strategic to merely trying to protect the third-party sellers. I would also add that, in cases where we're on the other side, requiring details like naming individuals could be very harmful to folks who say don't have all of the information that they need. So if a plaintiff is alleging that Officer X did something unlawful, but they don't know the name of Officer X when they're suing the district or our police department, that doesn't get their complaint tossed out the door as long as they allege that the officer did something that plausibly makes the conduct illegal. It's never been the rule that you need these kinds of specifics outside of pleading actual fraud. And so we would just push back very strongly on the idea that those kind of even more detailed allegations are necessary. I would also note, in terms of the allegations that we have allegations involving competing platforms, that Walmart.com, for example, is routinely fielding requests to raise prices. We quote testimony from the House subcommittee where a competitor there was talking about how prices are routinely raised on their platform in response to these most favored nations agreements. And so we think that we have pled, quite frankly, more than enough to show direct anti-competitive effects, enough to prove indirect anti-competitive effects, and enough to prove a per se case. And, while the trial court may well be more comfortable with additional factual allegations, that doesn't make it a legal requirement. I should say, too, that we do have a second amended complaint here that we put forward in our motion for reconsideration, which does exactly the same things that Judge Puig-Lugo wished that we had done the first time around, which was essentially completely ignored and dismissed out of hand. So there's that problem as well.
Do you think the second amended complaint, whether or not leave should be filed leave should be granted to file that, is that issue properly before us? Or did you proffer the complaint after Judge Puig-Lugo had dismissed?
So we think certainly the Rule 59E issue is before you, and we think that and the Rule 15 issue, whether to allow amendment of the complaint, are somewhat intertwined. That said, our preferred form of relief in this case would be a straight reversal, just a holding that Judge Puig-Lugo's original ruling dismissing our complaint was in error. And I think that would moot both the Rule 59 question and the Rule 15 question. But even if the court were to want to get into the Rule 59E question as to whether the court should have reopened the case to consider our second amended complaint, I think the court below obviously abused its discretion. We think it abused its discretion because there was the obvious legal error in dismissing the complaint in the first place. There was also the obvious legal error in dismissing the complaint with prejudice, which you should only do if it's not plausible or possible to plead additional facts that would make the complaint viable.
Don't you usually decide whether it's not possible to allege curative facts by looking at a proposed amended complaint?
Yes, I mean, typically one does that, but I think it can also be evident from the nature of the dismissal. I mean, even when there isn't another amended complaint on the table, courts routinely do say, I'm dismissing, but without prejudice, because what I dismissed on was a lack of adequately pleaded facts. And one could imagine adding additional facts to these claims that would save it. Courts do that sua sponte not infrequently. And so I don't think it was a requirement that we have a complaint pending before Judge Puig-Lugo before he considers that. But certainly by the time we get to the motion for reconsideration, when we do have a second amended complaint that he can look to see, gosh, there are ways to cure these purported factual infirmities that I think I see in the first amended complaint. To not look at that at all, to just say without any reason or explanation, no, I already dismissed this with prejudice denied, that's textbook abuse of discretion under Foman versus Davis. So again, we don't think the court needs to get into that. We think you can just look at the first amended complaint and say, this is certainly enough to state a claim. And we think that Judge Puig-Lugo's principal errors were, one, as we discussed earlier, misinterpreting Twombly, and two, in essentially taking issue with these factual allegations that we have made or ignoring them outright. For example, one of the things Judge Puig-Lugo said was, well, if these sellers don't like Amazon's fees, they can just go somewhere else. But we allege in our complaint that that is just impossible for sellers. We allege that sellers have said that if they can't list on Amazon, I guess this is at JA11. Most third-party sellers believe that to successfully sell online, it is imperative that they have a presence on Amazon's online marketplace. And at JA28, we say most sellers are now compelled to become sellers on Amazon's online marketplace or forgo access to a majority of online shopping traffic. And we also, not only do we explain that that is the case, which has to be taken true because it's a factual allegation, we also explain why you can't escape Amazon, why it is this 800-pound gorilla in the room, in that it has this huge market share, potentially as much as 70%. It has millions of third-party sellers and a huge number of buyers, which create these tremendous network effects. Because the more buyers you have, the more sellers you're going to attract, the more sellers you have, the more buyers you're going to attract. And so many third-party sellers very reasonably think that if they don't list on Amazon, they're not going to be able to get the volume of business that they need to be able to succeed. In other words, there's simply no escaping Amazon for most of these retailers.
You have just described something that might not be nefarious or objectionable at all. Arguably, Amazon was in the right place at the right time. And when the pandemic hit, you know, they were the only game in town, to exaggerate. They could have acquired all that market share in a perfectly legitimate fashion, correct?
Correct. In and of itself, being a monopoly or having market power is not unlawful. That's right. But what is unlawful is to use it then in an anti-competitive way. Under Section 1, to do that in agreement with other parties, and under Section 2, to do it in a way that is.
So it's okay to get the monopoly effect, but to protect it with these agreements is forbidden.
Yes, if you're protecting it in an anti-competitive way. It can also be unlawful to acquire monopoly power if you do it in an anti-competitive way. But posit a world where Amazon just did this by being absolutely the best online marketplace platform in the business. Even then, if what it's doing is using its market power and these tremendous barriers to entry that are created by network effects, among other things, and by the fact that it is invested at a loss in programs like Prime, right? That are highly desirable and hard to replicate. If it uses that power in concert to fence out competition, not by pricing aggressively, not by continuing to innovate, but by sitting tight and keeping everyone else out, that is the definition of a Section 2 claim. And here, where you have other parties who are involved, it also absolutely states a Section 1 claim. And I would note that these days, you can't walk down a street in the district without seeing an Amazon Prime truck driving around. And so if we are correct that, in fact, this Amazon tax is being passed on to consumers, not only on Amazon, but across the internet through these sales prices where consumers aren't even aware of what's happening. The massive nature of that anti-competitive effect can't really be overstated. It's very important when someone with a monopoly power like this exerts it in a way that fences out potential competitors, that they be brought within the ambit of the antitrust law and that we at least have a chance to make our case. One of the things about this case that I think is very important to realize is we're at a motion to dismiss. This is not summary judgment. This is not post-trial. Many of the cases that Amazon relies on are. All we have to do at this point is plausibly state a prima facie case. We don't have to consider proposed pro-competitive effects that Amazon is putting forward. We don't have to consider, well, maybe we're also just the best and there are some good effects coming from these agreements. That's something that gets fought out at summary judgment. We would love to get there. We would love to put up our experts. We would love to have that debate. But our complaint was essentially cut off, and we filed over 2 years ago. We were the first government enforcer to take Amazon to task and try to hold it accountable for this anti-competitive conduct. And over 2.5 years later, we haven't had a chance to present a shred of evidence. And really, as we stand here today, that is all that we're asking for, is the opportunity make our case. We think that we have the allegations that are sufficient to get us there. And we would be happy to have the opportunity to present more evidence when the time comes.
All right, thank you, Ms. Van Zyl. Unless there are any further questions from Judge Fisher, we will hear from counsel for Amazon, Mr. Shanmugam.
Thank you, Judge Deal. Canon Shanmugam of Paul Weiss for Appellee Amazon. May it please the court. This case involves a counterintuitive and ambitious theory of antitrust liability. Namely, that provisions in agreements between Amazon and sellers that on their face protect consumers from higher prices, in fact, have an anti-competitive effect across all of e-commerce by raising prices on other online marketplaces. The district has failed to make plausible, non-conclusory allegations to support its claims that these provisions constitute agreements to restrain trade with anti-competitive effects. The provisions themselves, by their terms, merely prohibit price gouging or, in an earlier form, price discrimination, and reflect Amazon's efforts to bargain for lower prices from its suppliers so that it can offer lower prices to consumers in its online store.
I might agree that it would be counterintuitive if you discounted Amazon's fees and commissions that come across through each sale. But once you take those into account, I don't see what's counterintuitive about it. I mean, the rough theory is this, you know, for every $100 sale you make on Amazon, $15 of that goes to Amazon. And so you might be able to sell that product at the same profit margin for $85 on your own website. But you won't, because you'll be boxed out of Amazon if you do, therefore raising prices on your own website and competing websites that have lower commissions and fees. Nothing about that strikes me as counterintuitive. Why do you think it is?
So I think it's counterintuitive, Judge Deal, for the simple reason that as the district itself acknowledges on the very first page of its brief, when you look at the terms of the agreements themselves, they serve to lower prices for consumers. Now, we freely acknowledge that that's not necessarily the end of the inquiry. Our fundamental submission to this court is that the complaint is simply deficient when it comes to alleging anti-competitive effects from the agreements. And we certainly recognize that there are agreements here. But when you really boil down the district's argument is in essence that you can survive a motion to dismiss in a case like this simply by identifying agreements. And again, we acknowledge that there are express agreements here, and then adding in a speculative theory as to how those agreements could cause anti-competitive effects.
Aren't you in effect insisting that the agreements have to be illegal on their face? Amazon has good lawyers. They have PR people who name this a fair price provision. And you're not saying, are you, that one has to see an agreement that on its face requires anti-competitive conduct?
Judge Fisher, we certainly acknowledge that there are certain types of agreements that are inherently anti-competitive, that are on their face anti-competitive, agreements like agreements to fix prices. Those are the sorts of agreements that, of course, courts subject to per se treatment. These agreements are plainly not in that category, as the district tacitly acknowledged when it stripped all of the allegations of per se classification from its first amended complaint. My point with regard to the agreements is simply that if anything, on their face, these agreements would seem to be pro-competitive. But we acknowledge that you have to look at the evidence and the allegations here, because we're at the motion to dismiss stage of anti-competitive effects. And at bottom, our fundamental submission to this court is that those allegations are plainly insufficient. And I'm happy to go directly to the allegations that General Van Zyl identified. Unless you have a question, Judge Fisher, you look like you're about to have one.
I had half a question. Let me complete it. As I understand the complaint, it says the way this agreement is interpreted and enforced by Amazon reveals that its effect is anti-competitive. So we're not saying the agreement by its own terms is illegal, but when you look how that agreement is applied in practice, enforced in practice, here's what we come up with.
Sure. So Judge Fisher, I'm happy to address that. And this also goes to a question that I think Judge Deal asked my friend earlier. So I think we're really talking primarily here about the marketplace fair pricing policy, which again, by its terms, provides that sellers cannot set prices that are significantly higher than recent prices on Amazon or elsewhere. Now, the district makes the allegation that in practice, Amazon enforces this policy in a way that essentially applies to all price discrimination, that it involves not just cases where the price is significantly higher than recent prices, but even cases that involve smaller price differences. Now, in our view, there's not evidence of an agreement as to that incremental step, but ultimately that's really kind of irrelevant to the fundamental reason why this complaint should be dismissed. We make the point simply to note that you've got to actually identify the agreement between the parties, whether express or otherwise, before you proceed to the next step of the analysis. But it's really on that next step of the analysis that the district ultimately falls down. And again, I'm really happy to talk in any detail about the allegations in the complaint, because we would submit that they are plainly insufficient. And I would note that we are dealing here with a first amended complaint, which was filed in response to Amazon's initial motion to dismiss, which made all of these points about the insufficiency of the original complaint.
It's a long complaint, but it would be helpful to me if you addressed at least some of the reasons you think the allegations are insufficient.
I'd be glad to go directly to the two allegations that my friend identified. The first is the allegation on Joint Appendix 18, and it's the allegation in, I believe it is paragraph 24 of the first amended complaint. And that is the allegation that third-party sellers regularly increase their prices on other online marketplaces in order to avoid Amazon's sanctions. Now, that allegation does not identify any particular seller. It does not identify any particular product, but more generally, it doesn't explain why any seller would actually have the ability to raise prices on another platform. And regardless of which of the three agreements, provisions that we're talking about here, that's really the fundamental conceptual problem with the district's approach here. It is that for sellers or suppliers to be able to charge super competitive prices on other platforms, they have to have market power in those particular product markets, or else they will naturally be undercut by competitors in those markets. And that's why a conclusory allegation that there's somehow this across the board effect. And keep in mind that the market as defined by the district is all of e-commerce. So we're not talking about particular product submarkets. You have to have plausible allegations of anti-competitive effects across the entirety of e-commerce. That allegation is both conclusory and insufficient.
Well, what about on their own websites? You don't need to engage in any sort of what's their market power when determining, the Via Heart example in the second proposed amended complaint, where my memory is the allegations were this was a product that if they sold for $114 on their own website, they could realize the same margins as they realize on Amazon through a $150 sale, thanks in part to what I think was something like a 15% commission that Amazon charges. But they don't do it. They won't charge $114 because that would run afoul of the price parity provision, the fair pricing. Getting confused which one's in effect now, the fair pricing policy.
The fair pricing policy.
That they would basically be subject to sanctions by Amazon. What's implausible about that?
So let me first explain why that would be insufficient. And I do want to say a word about why the Superior Court correctly refused to permit the amendment after the dismissal. With regard to the second amended complaint.
I actually, if I could just hold you in place for a second. I didn't mean to really trudge up the second amended complaint. I just mean as in terms of plausible allegations in the first amended complaint, there are also references to sellers using their own websites. You don't need to engage in any sort of fanciful thinking about how much market control they have. It's their own website. They can set the prices they want. So why isn't that an anti-competitive effect?
So I do think that my point about how they will be undercut regardless of where they're selling, unless they have market power in their particular product market, still holds. But let me address the Via Heart allegation, because I think maybe in the concrete context of those allegations, I can bring out sort of why we think these are insufficient. So in the second amended complaint, we actually do have a single identified seller to support this theory of anti-competitive effects across all of e-commerce. It's this toy manufacturer Viahart. And what the district is doing is relying on a Medium article written by the CEO criticizing Amazon for various practices. Those allegations, as you indicate, Judge Deal, suggest that Viahart was forced, in its view, to charge higher prices because of the fair pricing policy. But when you look at those allegations affirmatively showed that Viahart could still make a profit on Amazon by lowering its prices to meet the hypothetical price that it would charge on its own website. And so it's really unclear from those allegations why Viahart would prefer to charge a super competitive price on its own website when it would be subject to price competition. And so we would submit that that allegation itself is still insufficient. And even if you accepted that that allegation was sufficient in the particular context of that particular toy to show super competitive pricing, again, it's a district's burden because the district has chosen to allege such an ambitious market, all of e-commerce, to come forward with allegations to be able to generalize from that one example to the entirety of internet commerce. And so even if that had been included in the first amended complaint, we would say that that is still insufficient.
I mean, one thing that comes across from the first amended complaint is, as with Amazon, these sellers have some authorship over what their products are being sold for on third-party seller sites. They talk about reaching out to Walmart and saying, you need to raise our prices so we're not running afoul of Amazon's pricing policies. Do you think, A, that's implausible that they have that type of influence over somebody like Walmart, where it seems, frankly, pretty plausible to me that Walmart would want to keep third-party sellers happy. Otherwise, they might pull their own products from Walmart, and Walmart is fledgling as compared to Amazon in the online retail space. So what's implausible about thinking they have that type of authority over what their products will be sold for?
So Judge Deal, that brings me to the second specific allegation that General Van Zyl identified, which is the allegation on Joint Appendix 31. So this is paragraph, I believe it's 62 of the first amended complaint. And that allegation is, quote, Walmart routinely fields requests from third-party sellers to raise prices on Walmart's online marketplace. Now, you'll notice what's missing there, which is any allegation that in fact prices were higher on Walmart's online marketplace. And notwithstanding the suggestion that this is all something that is taking place in the shadows, we're talking about actual pricing. That information is all publicly available. And so if there were such examples, one might expect the district, at least by the time of the first amended complaint, to have come forward with them in the complaint itself. And General Van Zyl at one point in the argument said, and I'm quoting, the massive nature of these anti-competitive effects cannot be overstated. Well, again, one would think that if this was so massive, that there would be at least one example. And we're not saying that the district has an obligation to name a particular seller, but there's no particularized allegation in the first amended complaint at all, not with regard to any particular seller, not with regard to any particular product, not with regard to any particular product market. And all we are submitting, and I think that this was Judge Puig-Lugo's fundamental insight here, is that the Twombly standard requires something more. It requires plausibility. And so where you have conduct in the words of Twombly itself that is equally consistent with innocent behavior and unlawful behavior, you have to have something that moves the needle towards unlawful behavior. And to be sure, as General Van Zyl pointed out, that was in the context of determining whether or not you had an agreement. But General Van Zyl rightly concedes that the same plausibility standard, of course, applies with regard to anti-competitive effects as well. And I do think with respect to the district, that this effort to amend the complaint comes far too late. One thing that is sort of telling about how all of this went down before Judge Puig-Lugo is that when the judge dismissed the complaint, and obviously the presumptive rule is that a dismissal is with prejudice, the district actually didn't challenge that. The
presumptive rule is what?
That a dismissal is with prejudice when the judge does not state the form of the dismissal, The
But
district did
I
not.
thought there was a lot of case law that says judges ought to lean in favor of dismissing without prejudice and then consider a bunch of factors before they dismiss with prejudice.
Well, what's interesting about what happened, Judge Fisher, before the Superior Court is that the district actually didn't sort of separately argue that the Superior Court erred by dismissing the complaint with prejudice rather than without prejudice. The district simply asked after the dismissal for leave to amend. The Superior Court then clarified that the dismissal was in fact with prejudice. And I would submit that I think that that was entirely appropriate, not least because the district had had the opportunity once to amend the complaint in order to add further allegations and had failed to do so. And I think that the district by now seems to concede that in order to get leave to amend after the dismissal, the district would have to satisfy the requirement under Rule 59E that there be manifest errors of law or fact. Of course, as I said to Judge Deal in our earlier colloquy, our fundamental submission is that it would be futile to grant leave to amend here because the second amended complaint is still insufficient. Now, the district sets great store by the fact that there are other cases that have been brought against Amazon that have gone forward. And the district, I think, primarily relies on a federal district court decision, the Frame-Wilson decision from, I believe, the Western District of Washington. Now, I think with all due respect to those courts, it's very hard to draw any meaningful conclusions from those decisions because they contain, quite frankly, fairly limited reasoning. This court is the first appellate court to consider a complaint of this variety. On the Frame-Wilson decision, I would just make 2 points. First, that the Frame-Wilson decision really doesn't come to grips with the actual language of the agreements themselves. And second, that that decision seems to rest on an erroneous premise, namely that, quote, Amazon's pricing policy requires sellers to add Amazon's fees to the cost of their products when they sell them on all external platforms. Now, the district may very well allege, though it does so without any particularity, that that effect is taking place in the marketplace. But I think that the district court in Frame-Wilson, to the extent that it thought that that was actually required, was mistaken. I would also note that the complaints in those cases.
I'm just getting confused exactly what your point is. So, I mean, I think, yeah, the district's allegations here are roughly that. Not exactly. It's not that you have to tack on Amazon's fees to wherever else you're selling it. But it's to the extent you could sell at a lower price and still make your same margins. Amazon has higher fees. You can't undercut them. So you're basically baking those fees into the price of wherever you're selling it. That's roughly the allegation.
Yeah, and my point, Judge Deal, is simply that because the district court in that case didn't really talk about the terms of the agreements, it's unclear how the district court was actually characterizing them. I would note that the complaints in these cases are also, very different. Some of the complaints, like the Frame-Wilson complaint, contain more specific allegations about particular sellers and submarkets. Some of these complaints challenge only certain of these provisions and not others. The FTC's complaint, which General Van Zyl referenced, is, I think, very different. It focuses primarily of the 3 provisions that are at issue here on the now defunct parity provision. And so I don't think that this court can really draw any general conclusions other than that, the district's complaint in this case is on its terms deficient. And again, if it is really true that these effects are as pervasive as General Van Zyl claims, one would think that the district, particularly armed, as we point out in footnote 4 of our brief, with enormous civil investigative power, would have been able to include some specific allegation in the complaint. And yet the district didn't do so.
Let me ask you a hypothetical, and this will ask you to explain the essence of your position in very simple terms. Let's assume hypothetically that I'm qualified to be a trial judge and the first amended complaint comes before me. And I think to myself, these are very serious allegations. If they're true, this is a big deal. Maybe they're true. Maybe they're not. I'd like to know more before I put an end to these allegations. I think you're saying it would be wrong of me to do that.
Judge Fisher, it would be wrong for you to do that here, and let me explain why. I well understand the judicial impulse on motions to dismiss, to just think, what is the harm in permitting this to go forward? And it can be resolved at a later stage if the district doesn't bear its burden, say at the summary judgment phase. But I think that there is something inherently dangerous about doing that in this particular context. And it's a point that's made by the amicus briefs on our side. In essence, what you would be doing if you permit this complaint to go forward is to permit antitrust plaintiffs, whether it's the district or any private plaintiff who can claim injury, to come forward and to say, look, we have an agreement here. We think this agreement could have anti-competitive effects. We have a theory as to how those anti-competitive effects should result. Permit this to go forward. And I would submit that it's no accident that the now familiar plausibility standard, which of course applies across the board in the district as in federal court in civil actions, first developed in precisely the context of an antitrust action. Because of course, all the time you have antitrust cases where you have conduct that could be equally consistent with innocent free market conduct and unlawful conduct. As was discussed towards the end of my friend's argument, this is really a case involving a great American success story, Amazon, that developed strength in the marketplace precisely because it was offering an innovative product, the ability to buy anything and to have it delivered to your door, which, at a time not so long ago was novel and is now familiar. And so a court has to be very careful in parsing a complaint to make sure that there are plausible, non-conclusory allegations. And that's really what is crucial here. It's not enough simply to allege there are anti-competitive effects without more, or to allege there could be anti-competitive effects. There has to be some evidence of actual anti-competitive effects taking place.
So I guess I agree with you this far. To the extent that the district has theories about how these agreements operate in practice, maybe that's not sufficient. But there are allegations of how it did in fact operate in practice. And so that causes me to focus on whether those are conclusory, plausible. You know the drill.
Yes, and Judge Fisher, what I would say about that is let's go back to what General Van Zyl said, and I think this is entirely consistent with the district's brief. The two things that she focused on were the allegation that sellers regularly increase prices on other online platforms, and the allegation that Walmart routinely fields requests. Our fundamental submission is that that is just not enough. It's not enough to allege that there are routinely anti-competitive effects, that sellers routinely raise prices. That is a conclusory allegation. There has to be something more than that, not least because of the conceptual difficulty that I identified, which is that sellers are ordinarily in a free market not going to be able to raise prices on their products unless they themselves have market power in that product market. It is not plausible to say that Crest, to take an example, can go out and raise toothpaste prices to super competitive levels when it is in a competitive market against Colgate, because Colgate will simply undercut that. And that's why the district had to do more, had to provide some degree of specificity in order to get past that hurdle, particularly given the market definition. And we are not here to challenge independently the market definition. We're just holding the district to its own allegations for this purpose. It's one thing if the district said there are anti-competitive effects in the toothpaste market. But here, the district's allegation, this is the most ambitious part of their complaint, is that these effects were taking place across e-commerce. The defined market on the district's part here is all online marketplaces. That is in many ways a broader defined market than the market in, say, the FTC case and in other cases. And so the district has to be held to that. They have to show plausibly that there were anti-competitive effects across the entirety of e-commerce. And our fundamental submission is that for all of the pages in the complaint, when you get right down to it, on this issue of anti-competitive effects, as opposed to alleged market power, all the district has is the allegations they've identified.
Isn't the response, well, Crest can bake in the 15% Amazon fees to wherever else they want to sell their product because they know full well Colgate's going to have to do that as well. if you have a monopoly in Amazon, that those fees are just going to be baked in for everybody. So it's still an even playing field. You're not going to be undercut. If you are undercut by Colgate, well, great. They'll be kicked off of Amazon's website because they're not matching the 15% extra fees. And that's just going to be more of a market share for you. I mean, I'm just not sure what's implausible about that. I mean, we all know Amazon is a behemoth. If it's true, this has been specifically alleged, they charge the highest fees and commissions. If it's true that you can't undercut their prices, the third-party sellers are not allowed to undercut their prices elsewhere without being kicked off of Amazon, then I don't see what's implausible about they'll do everything they can to bake it into the price on other party websites. They can certainly control those prices on their own websites. And I don't find it particularly implausible to say that Walmart would listen to their distributors when setting prices for products, or that you could just raise the prices at which you're selling it to Walmart if they're not going to listen to you or stop doing business with them. I mean, none of that seems, I get that these are questions, but they seem intensely factual. They don't strike me as implausible.
So I would say two things in response to that. First, Judge Deal, that, when it comes to Walmart, those allegations that you just referenced are conspicuously lacking in this complaint. The complaint stops at the, sellers ask Walmart to raise prices. There's no reason, there's no allegation.
That same paragraph you pointed me to says they can't sell it for lower prices on Walmart's website, though. It's true that there's never and Walmart exceeds, but I think one or two sentences before they make that request, it also says the sellers can't sell at lower prices on other websites, which at least, being a little charitable and reading a complaint, you might read to say, Walmart exceeds to those requests.
Yeah, so I would just say one other thing on this sort of broader point about the importance of, market power in the product markets, which is that to the extent that the theory here were that, all of the players in a particular product market were in the same position, that still leaves open the possibility that if that is in fact a competitive product market, that particular sellers could charge a lower price on Amazon itself in an effort to develop market share. And of course, there's no suggestion that there aren't other online marketplaces available. And so I think when you put those two things together, what we're really discussing here is, the theoretical plausibility of all of this, but a theory is not enough. The best authority for that is Twombly itself. You actually have to have actual allegations that in the real world, these anti-competitive effects are occurring. And again, that's really what is lacking here. And the fact that even in the second amended complaint, the most that the district can come up with is this one particular seller is, I think, telling. In the face of Judge Puig-Lugo's identification of this problem, that was the best that the district could do. And so if the plausibility standard is to mean anything, I think it is that a plaintiff has to come forward with something specific. And it doesn't necessarily have to be a specific seller, but it does have to be some meat on the bones beyond the bare legal requirements. And really, that's what's lacking here.
Thank you, counsel. Unless there are any further questions, we will give Ms. Van Zyl a few minutes in rebuttal.
Thank you, Your Honors. There are just 3 points that I want to discuss briefly. The first being this allegation that we are somehow required to allege that all the third-party sellers have market power in and of themselves. I just want to be very clear that that is not an element of a Section 1 claim. You will not find a case saying so. It appears to be invented out of whole cloth by Amazon. And
I think the argument is that it goes to anti-competitive effects, that if and this, it is at least a little conspicuous, so let's give you a chance to answer it, that there isn't the allegation in the first amended complaint that when these third-party sellers make requests of Walmart to raise prices so that they don't undercut Amazon, that those requests are acceded to. Do you have a different view of what's alleged in the complaint?
So we don't, in the next sentence, allege and Walmart complies. That is true. But as you pointed out, Judge Deal, we allege elsewhere that they do, in fact, raise their prices. That's a factual allegation that has to be taken as true. It's not conclusory. It's not just saying they set super competitive prices. That would be a legal conclusion couched as a factual allegation. It is sellers, in fact, raise their prices on specific platforms, which include Walmart. We also think that at this point, we're at the motion to dismiss stage.
Can I just ask a question about that? Because you might be able to point me to the right allegation. Is it alleged that Walmart, like Amazon, is, you know, a website where third-party sellers get to set their own price? It sounds like the answer is no. It sounds like they're making requests of Walmart. So is there, point me to your best allegation of, and, you know, Walmart abides by these third-party sellers. Walmart cares. They bring these complaints to them.
Well, I think probably the closest we get is in paragraph 33 of our complaint, where we allege a lot of detail about Walmart's pricing structure and how it's lower. They also are an agency website. They charge commission fees. And my understanding is, in fact, that they operate in the same way as Amazon is this intermediary, where an agent where the sellers do get to set their own prices. And I think that that's a fair inference to draw from our complaint. Amazon's requirement that we connect every dot exactly with specific names and dates simply isn't how Rule 8 works. And moreover, I would say, Judge Steele, I think you got it exactly right as in your colloquy with my friend when you were explaining why we might not expect to see price discipline or competition coming from competitors. We've alleged in the complaint that there are millions of sellers listing on Amazon, that in fact sellers feel compelled to list on Amazon if they're going to make any money in e-commerce, and that by contrast, one of the nearest competitors, Walmart, has only slightly over 100,000 sellers. And you can see from our allegations that there's overlap there. So just as you point out, if I am Colgate trying to compete with Crest, and I look and I see that they're listing on Amazon, I know that they are also subject to this most favored nations clause. I know that they also have to build in Amazon's fees to pay that Amazon tax and charge it on every other website. And so what it does is it softens competition, not just between marketplaces, but also between different products. And the second point that I wanted to make is to address this contention my friend makes that our claims are somehow facially implausible about how this market works. Not only do we have those concrete factual allegations that have to be taken as true, that prices are in fact raised on other websites by these sellers, but we also have the Yale Law Journal article and an amicus brief from a number of antitrust scholars explaining actually that if we're talking about theory and how you would expect this to work, this is exactly how you would expect a most favored nations clause in this platform format to work. You would expect anti-competitive effects and raise prices. And in fact, in Europe, where they have banned most favored nations clauses on travel sites that are very similar platforms that act as agents for those who run hotels, when they eliminated those clauses, prices decreased, but supply did not, which I think shows that our theory has legs. And I don't imagine that Booking.com or Expedia.com, that every single hotel listing on those websites has market power. And so I think it's very plausible to infer that these anti-competitive effects can in fact be true, that this is in fact how the real world operates, given all of the evidence we and scholars have put forward. I would also just flag.
Let me interject right now. You just used this phrasing, very plausible to infer. If you had the first amended complaint with no allegations about how this was enforced in practice by Amazon, would that be enough to get you past the 12B6 motion?
I think it still plausibly could be on anti-competitive effects. And let me explain why. This is actually exactly what I was about to say. So I think you read my mind, Judge Fisher. On page 11 of the Antitrust Scholars brief, they talk about what's necessary to plead anti-competitive effects through an indirect method. And what you need through an indirect method is just market power. And I think we've proved market power. I don't take my friends at Amazon to contest that they have market power here, plus some other ground for believing that the challenged behavior could harm competition. And that's from the Tops Markets case in the Second Circuit. We think that's a correct statement of the law. And we think here, where not only do you have the factual allegations that prices were raised, but you also have all of these scholars coming forth with economic models that show again and again and again that most favored nations clauses on platforms have broad anti-competitive effects and do raise prices. We actually think that that in and of itself would get us past a motion to
So you
dismiss.
think could have this effect is an equivalent of plausible?
In this context, if we have market power as well, yes, I mean, that is certainly what the Tops Markets case says, but we think we've gotten past could. We don't think you have to really wrestle with that question again, because of the factual allegations that are in our complaint that sellers are in fact behaving in this way. And then the final point, and to that point, I think at the motion to dismiss stage, what my friends would need to show is not just that maybe these agreements are pro-competitive. I think they would need to allege that they are pro-competitive as a matter of law, because the pro-competitive justifications come in during the burden shifting that happens at summary judgment. They don't generally come in at the motion to dismiss stage. And I don't think that they've come anywhere close to showing that just as a matter of law and economics, these kinds of agreements are invariably pro-competitive. And the last point that I would make is that I don't see my friends offering any case dismissing an antitrust claim at the motion to dismiss stage that is even vaguely similar to what we have here. And that is in part because the analysis of whether there are anti-competitive effects is, as your honors pointed out, so fact intensive. It's generally something that is reserved for the jury. And when you do see cases being dismissed at the motion to dismiss stage, which is rare in antitrust law, but it's usually because either you have an alleged agreement, and we have a concession here that there is an agreement, or that the only harm alleged is harm to a competitor in a lawsuit brought by the competitor. And what antitrust law cares about is harm to competition, not harm to competitors. And we have alleged harm to competition here in spades. So for those reasons, if there are no further questions, we would respectfully ask that the court reverse and allow us to move forward to discovery and summary judgment. Thank you.
Great. Thank you, counsel. We appreciate your briefs and arguments. The case will be taken under advisement and will be submitted. We'll hear argument in our next case, number 22 CV 605, American Federation of Government Employees, AFL-CIO, Local 631 versus DC Public Employee Relations Board. Right. Ms. Hutchinson, whenever you're ready.
Good morning, Your Honors. I'm Barbara Hutchinson, representing AFG Local 631 in this matter. I would like to reserve 2 minutes for rebuttal.
Okay.
This matter is before the court on the decision that was entered by the DC Public Employee Relations Board, and the initial, excuse me, I need to get my glasses. The initial decision of the Public Employee Relations Board was opinion 1804, and it was appealed to the Superior Court. And on July 13th, Judge Pugh Lugo upheld and affirmed the Public Employee Relations Board's decision. The decision affects AFG Local 631, which represents employees of the District of Columbia government, and the employees that are represented by Local 631 cover a range of government agencies: the Department of Public Works, the Department of General Services, the Department of Energy and Environment, the Office of Contract and Procurement, and also zoning and planning. All of the employees that are in these agencies are actually essential employees. Many of them are identified as essential employees. which made this case and this decision extremely important for employees in in those agencies, because if there is an emergency, and the Public Employee Relations Board's opinion 1804 they ruled that under DC Code 617.08A6, which defines management rights, and in emergencies, the Public Employee Relations Board ruled that the district could implement changes to working conditions without bargaining with the union in any way. They didn't have to bargain on impact and implementation, and they didn't have to bargain over any changes in working conditions if there was an emergency.
But that ruling wasn't based on the CMPA. That ruling was based on the emergency legislation, saying that notwithstanding anything in the CMPA, they can implement these requirements without negotiating over impacts and effects. And that legislation that the PERB's ruling was based on is no longer, doesn't exist anymore.
That is not accurate.
All right. What's inaccurate?
And actually, the board's opinion said that they were interpreting DC Code section 617.08A6, and that under that emergency management right, that the district could make any changes to working conditions for employees without negotiating with the union. They based their opinion on the case of the Office of Labor Relations and Collective Bargaining versus the Public Employee Relations Board. Their opinion specifically stated that they were actually interpreting the DC Code and not necessarily the COVID-19 Emergency Act. They specifically said that the code under the emergency management right provided that you could make these changes in working conditions, and they did not reserve it to being interpreting the COVID-19 Response Emergency Amendment Act. Can you just point me to where that is in PERB's decision that's on appeal right now? Because what I see is they're citing to the Emergency Act. They say notwithstanding, quoting the notwithstanding language, which is also quoted from the Superior Court opinion that they're relying upon. That comes from the Emergency Act. Okay.
Notwithstanding the CMPA, they can do these things. Now that might be a wildly overbroad reading of the Emergency Act. But it does seem nonetheless to be a reading of the Emergency Act. And so where in PERB's ruling do you think it's untethered from the Emergency Act?
In the appendix is opinion 1804, and at page 6. And this is specifically from the opinion. This is the quote: under the CMPA, DC Official Code 1-617.08A6 authorizes management to take whatever actions may be necessary to carry out the mission of the district government in emergency situations. The agencies assert that vaccination are in furtherance of this management right. Relying on the Superior Court's ruling in OLRCB versus PERB, the board finds that the agencies have the management right to unilaterally effectuate the vaccination requirement, and any proposal by the union in their current context of bargaining is non-negotiable. So they did not rely on the COVID-19 Act. And that is really the importance of this issue, because if the board's opinion is left to stand, then in any perceived emergency, the district would be able to go forward and make changes to working conditions without bargaining with the union. That would be an amendment of the Comprehensive Merit Personnel Act. The Comprehensive Merit Personnel Act was never interpreted to provide that the district could make changes to working conditions
So
without bargaining with
can
unions.
I ask in terms of what you're asking of us? Would it
What-
suffice to say, PERB, your order has these two paragraphs. One seems to be interpreting the COVID-19 Response Emergency Act of 2020. It's the paragraph right before the one you just read, saying that notwithstanding any contradictory provision of the CMPA, yada, yada, yada. And then there's this other paragraph that would seem to suggest that under the CMPA directly, there's no obligation to, in an emergency, to negotiate over impacts of effects, regardless of the Emergency Act. To the extent you meant that second thing, that's wrong. Would that satisfy, and to the extent you were relying on the Emergency Act, that's moot. We don't need to grapple with that. Would that satisfy your claim for relief?
That would, Your Honor, because it would put the Comprehensive Merit Personnel Act back into its original interpretation. At this point in time, even though, there was no emergency, as we pointed out, and we brought that up with PERB, that there was no public emergency, it had ended. The fact of the matter is this provision would permit the district in dealing with the unions to, if the mayor declared an emergency, they could change working conditions without bargaining with the union at all based under this decision.
Would you clarify for me what relief you are asking from us?
We
I
are,
had understood from your brief that you wanted us to order bargaining over the impact and implementation of the mayor's order to vaccinate.
no, sir. We're asking for a reversal of this opinion. And if in fact, if the parties go back in time, they can't go back in time. The COVID-19 emergency is no longer in existence, and also the district removed the vaccination requirement. So we would not. I don't believe that we could get that relief, but we could get the relief which I just discussed, which says that in the event of an emergency, the district still is required to bargain with the union.
Let's assume the following, and I don't have the PERB's decision in front of me. Let's assume that the PERB's decision was based on a combination of the CMPA and the notwithstanding language of the Emergency Act. And we know that the Emergency Act has expired. It's no longer in effect. Where would that leave you with respect to whether you're willing to tolerate PERB's decision?
We would still have a difficulty because I understand what you're asking. Would that give us the same relief that we're seeking? I don't think it could, because if it's a combination, you're still changing the language in the DC code, because you are relying on a change to the Comprehensive Merit Personnel Act, which was never intended. In the OLRCB versus PERB case, the judge specifically pointed out that he was not interpreting the Comprehensive Merit Personnel Act. And this is the case that PERB relied on in issuing their ruling. So that interpretation of it being combined with COVID-19 and the Comprehensive Merit Personnel Act, I don't think that would cover the situation that we have.
I will confess that your brief has confused me in this respect. There are times at which your brief seems to say the mayor had no authority whatsoever to order vaccination. I had understood, however, that the complaint that you made to PERB and to the Superior Court was that, okay, she probably had the power to do this, but she could not do it without first bargaining with the union.
We never believed and in essence, never accepted that the mayor had the authority to issue a vaccination requirement, but we were obligated to come forward and attempt to bargain to protect the employees that we represent. But we never conceded that the mayor had the authority. I raised that issue with the district, and I also raised that issue in our negotiability appeal that we presented to the board. We questioned the authority of the mayor, but we did not concede that the mayor had the authority.
But
No.
you used the term negotiability appeal.
Yeah. Yes,
And I've understood that that's what's before us now. Was this negotiable or not? And it seems to me that the answer to that depends on what the Emergency Act said. And the Emergency Act is no longer in effect.
no, the matter of whether it was negotiable didn't depend upon the COVID-19 Act. That depended on the Comprehensive Merit Personnel Act. The Comprehensive Merit Personnel Act says that all matters are negotiable unless they are a management right. And management rights are subject to impact and implementation bargaining.
I understand
Okay.
that.
So, I'm
There's
sorry.
the notwithstanding language in the Emergency Act, which arguably said you don't have to negotiate. No matter what the CMPA says, you don't have to negotiate under these circumstances.
Well, the COVID-19 Act was not a blanket broad grant to the mayor of authority to not negotiate with the unions. What the notwithstanding clause was about was giving the mayor specific authority to take specific actions. Vaccination was not among them. The list of actions that the COVID-19 Emergency Act authorized were very specific personnel actions that the mayor was authorized to take. Vaccination was not among them. We argued that before PERB. We argued that before the Superior Court. We specifically cited the notwithstanding section, which listed only specific personnel actions that the mayor could take. The mayor could not just take any and every personnel action. It was limited to the actions outlined in the act, which is why we believe that this decision does need to be overturned because it is interpreting the Comprehensive Merit Personnel Act and attempting to change the authority for employees to bargain with the district over changes in working conditions.
To go back to a similar question that I asked earlier, sometimes when we find an appeal moot, we vacate the underlying judgment. We say this appeal is moot, we vacate the underlying judgment and remand with instructions to dismiss the case. I assume that would also be a remedy that you'd be fine with. Say, PERB, your judgment's vacated, dismiss this case.
That would suit us. Yes, Your
Okay,
Honor.
that's what I assume. Thank you.
Thanks. I'll reserve my time for rebuttal.
Okay. And we'll next hear from counsel for the District of Columbia. And Ms. Johnson, I assume are you splitting time with the Public Employee Relations Board?
We are.
Okay.
Yes, so,
Yeah, at the beginning, could you just let us know how you're dividing time?
okay, so I'll be arguing for 8 minutes and PERB's counsel will be arguing for 7. Good morning, may it please the court. Holly Johnson for the District of Columbia. There's only one issue that AFG has brought before this court, and that is whether it was entitled to impact and effects, also known as impact and implementation bargaining, regarding the manner of implementing the vaccine requirement. That question is moot because there is no longer a vaccine requirement, and it's not capable of repetition because that ruling was based entirely on an emergency statute that has expired. And AFG's brief concedes that the issue that the district pursued before PERB, that the vaccine requirement itself was a management right under the CMPA. In the conclusion to AFG's brief, AFG asks this court to order PERB to issue a decision requiring the district to bargain over impact and implementation of the management rights in 0.08A. So, and that's the issue that the district has an interest in. The district engaged in impact and effects bargaining and has never taken a position before PERB that it wasn't required to do so. So whether it is, I'm not saying we were or we're not. I'm just saying that's not a position we've taken, and that's not what I'm here to argue today. AFG abandoned any claim that the vaccine requirement was that the district, getting my words mixed up. AFG has abandoned its claim that the vaccine requirement was not a sole management right, that it was entitled. AFG brought this negotiability appeal to demand full bargaining. It had already gotten impact and effects bargaining. It brought the appeal to PERB to demand full bargaining. PERB said, not only are you not entitled to full bargaining, but because of this emergency act, you're also not entitled to impact and effects bargaining. And
Help me with that. By insisting on its right to full bargaining, substantive bargaining, how could AFG then say, okay, we'll accept I&I bargaining? That is, I'm trying to ask, did they in fact forfeit or waive their right to I&I bargaining by maintaining their position that they were entitled to more? They were entitled to substantive bargaining.
it's an interesting question. I don't know the answer as a matter of law. There is case law suggesting that by insisting on full bargaining, the district could have argued, well, okay, we're not even going to do impact and effects bargaining. I think that that's what the National Treasury Employees Union, which talks about a dispute about ground rules that involved full bargaining, that's what that held. But in this case, the district did engage in impact and effects bargaining. So whether it could have said, we refuse.
It did engage or did say, we will do it.
No, did engage in it. If you look at sort of the timeline of events, and this comes up on page, I think it's supported by page 15, which I believe is AFG's negotiability appeal, says that from August 11th to August 8th, negotiations proceeded. And if you look in the administrative record where the last best offers are presented, you can see that there was progress made with regard to some matters. For example, the first issue was who was going to pay for the testing. And AFG had demanded that the district pay for certain testing, and the district said, okay, we'll pay for it, but only if you use our testing program. There's like a specific testing program. So there was impact and effects bargaining that went forth. But regardless of whether that actually happened, what's important is that at the administrative record on page 30, AFG writes back when they send their last best offers in, the union has rejected your impacts and effects bargaining and rejects your last best offer. So it doesn't really matter whether, I mean, there's never been a dispute in this case about whether the district engaged in impacts and effects bargaining. I suspect the district could have rejected all impacts and effects bargaining once AFG demanded full bargaining under this National Treasury Employees Union, but that's not what we did.
Can I, not to sort of derail the more substantive conversation, but can I pick up where I left off with Ms. Hutchinson, which is, we have cases that are not consistent on this, but sometimes there's a Supreme Court case issued a couple of days ago that called Lawfer that touched on this about what the proper disposition is if a case is deemed to be moot. Sometimes we say we dismiss the appeal as moot. Other times we say, well, in fact, what we should be doing is we should vacate the judgment below and we should remand with instructions to dismiss the case. And that's the proper course when something is moot. And here, what AFG is complaining about, well, their continuing interest has really nothing to do with this case. So it's kind of a classically moot. But they say, but don't leave this PERB precedent standing because it's pernicious precedent. It's pernicious precedent that's going to crop up again and necessarily only in emergency situations. So it's going to evade some review. So what's your position on why not vacate PERB's judgment and dismiss and direct them to dismiss this case?
We would certainly prefer that PERB's ruling stand because the part of PERB's ruling that
you don't even agree with it.
No. That's I first of all, I don't want to say we don't agree with it. We're taking no position on the impact and effects bargaining because we don't have a dog in that fight. But there is another ruling that PERB made on full bargaining. That's the appeal. That's the negotiability appeal that AFG brought. And PERB held that the issuance of a vaccine mandate was a sole management right. And I think that's an important holding. AFG had argued that because the public health emergency had expired, that there was no longer an emergency under the CMPA, and PERB in its footnote 4 of its decision made a finding that because there still existed a public emergency, both federal and district public emergency, that the vaccine requirement fell under the sole management right, and thus AFG was not entitled to full bargaining. Now, if this court were to choose to order PERB's decision to be vacated, I don't think that would be the end of the world, but we would certainly prefer that it stand, at least insofar as it's ruling on full substantive bargaining, because not only is that correct, it's never been disputed by AFG since then. From the moment that PERB issued its decision saying you're not even entitled to impact and effects bargaining, from that point on, AFG abandoned its argument that it was entitled to full bargaining over the vaccine requirement. And we think that that's important. Now, PERB's decision, it only really has precedence in PERB. And even then, I think PERB doesn't have to stick by its prior decisions. But because there is a ruling there that has not been challenged, I think it would be strange for this court to find it moot and order dismissal, order vacatur, especially because I think AFG's reading of PERB's decision is unreasonable. I mean, PERB said that it was relying on OLRCB, and OLRCB relies on the emergency legislation. So I think this court could solve AFG's problems by dismissing the case or dismissing the appeal as moot and dropping a footnote that says, by the way, we read PERB's decision as based entirely on the Emergency Act with regard to impact and effects bargaining. Because regardless of whether you read PERB as saying that the Emergency Act broadly authorized the vaccine requirement, or whether you read it as saying that the Emergency Act authorized the specific proposals that were part of impact and effects bargaining, no matter how you read its ruling on impact and effects is clearly based on the Emergency Act, and the Emergency Act has expired. So we think that that part of it is moot.
Could you clarify something for me? Do you think PERB or the Superior Court ever ruled on the question of whether the mayor had the authority to order the vaccine requirement, as distinguished from the question of negotiability?
I do not think PERB was authorized to issue that order, and I don't think that's the argument that AFG made. If AFG is arguing for negotiability, then they are presuming that the vaccine requirement as an authorization is lawful. If AFG wanted to challenge the lawfulness of the vaccine requirement, it could have brought an original action in the Superior Court. In fact, AFG relies.
So then explain to me how the PERB decision will have future pernicious effect in Ms. Hutchinson's view. If they did not rule on the question of whether the mayor had authority to order vaccination, but argued only on bargaining, what does that mean when tuberculosis breaks out again and we have a vaccine requirement? That PERB's decision will stand for the proposition that that's a management right?
Yes.
And not negotiable?
Not negotiable, not fully substantively negotiable. I think that PERB's decision is best read as holding that, of course, the district would be required to engage in impacts and effects bargaining were there not an additional statute that says notwithstanding any other provision of law. But for this question, I don't think there's any pernicious, like longstanding effect of PERB's decision on impact and effects bargaining. For this to be repeated, for the same issue to be repeated, we would have to have another pandemic, another vaccine requirement, and an emergency statute that was worded exactly the same way. And that essentially, if this court were to issue a substantive decision regarding the wording of such an emergency act, it would be telling the council how to write its legislation in the future. And that's just not the sort of thing this court tends to engage in.
So the two of you are confusing me.
I apologize.
Is PERB's decision based on the CMPA or on the Emergency Act or on a combination of both?
It's either a combination of both, or the way I prefer to view it, but of course, PERB will speak to you about how to interpret it, is that there are two rulings and they're distinct. One ruling is on full substantive bargaining. which is the appeal that AFG brought to PERB. I mean, that's what AFG demanded before PERB. Full substantive bargaining, as in this cannot be imposed without an agreement with the union. And PERB ruled on that based on the CMPA. And I will note also that even if this doesn't fall under the emergency part of the management right, the district has two other arguments regarding sole management rights that PERB didn't even reach. So anyway, yes, full substantive, sole management right, which denies AFG the right to full substantive bargaining. And then there's a separate ruling on impacts and effects bargaining, which is the one where I say the district has less of an interest because we didn't dispute that. At least we didn't dispute that we were offering that here. Whether we were required to is another question. And that ruling is based on the Emergency Act. And I think if you take PERB at its word that it's relying on OLRCB, and then you read the OLRCB decision, it's very clear that there's two separate issues: substantive bargaining, CMPA, impact and effects, Emergency Act. And because AFG is only claiming impact and effects here, then the entire issue that AFG is pursuing is moot because the statute has expired. So it's not capable of, it's moot anyway, but it's not capable of repetition because the statute has expired.
And you wouldn't have any objection to vacating that portion of the PERB opinion if we were talking about only the requirement to negotiate on impacts and effects.
Correct.
But PERB might. So we'll hear from them, I suppose.
Thank you.
All right, Mr. Simpson.
Thank you, Your Honors, and may it please the court. I'm Jeffrey Simpson on behalf of the Public Employee Relations Board. I don't have much to add other than to possibly clarify PERB's position on what its order says, and it pains me to say that the decision isn't a model of clarity as far as it goes.
You would win points for candor.
Yeah, well, that's what I'm here for, Your Honor. So the decision is based on the combination of the CMPA and the COVID Emergency Response Act. And what PERB did is it looked at the decision by under OLRCB, which held that there is a flexible, open-ended ability to respond to an emergency. And there's a particular emergency here that prompted an Emergency Response Act that had notwithstanding language. And it looked at the context of the management right in this particular situation, which is not, and I'll agree with the counsel for the district, it's not capable of review. PERB is not saying that under any emergency that there is no impact and effects bargaining. PERB's original decision and its argument before OLRCB was that if there's an emergency, there's impact and effects bargaining when it's feasible. And in this case, there was an ongoing COVID emergency, a necessary response by the district to implement a vaccine requirement, and you don't want to delay it by bargaining. And so what came to PERB was full negotiability appeal. They said no, and no negotiability under the CMPA. This is a management right. It was not argued to PERB that the vaccine requirement was unlawful, that the mayor didn't have authorization to implement a vaccine requirement. So they made no determination on that. Any argument about whether the vaccine requirement was lawful is not part of this case. And so I don't think that the court should reach that decision in this case. And so the decision on impact and effects bargaining was a combination of that there are a number of specified provisions in the COVID Emergency Response Act. There's tours of duty, place of duty, leave, telework, that all by and large cover the proposals made. And so that the district would not be required to bargain over any of those. And OLRCB said, kind of in the backdrop, that there's a broad management right to respond to an emergency, and we got an emergency here. And so PERB's position was that in this particular context, impact and effects bargaining was not appropriate. So I don't know if
you say in this particular context, do you mean because there's, Ms. Hutchinson highlights the paragraph that one would have to that's a little troubling. You know, the paragraph, there's two paragraphs back to back on page 6 of the appendix in PERB's decision. The first one seems to say, look at OLRCB, in which the court said the COVID-19 Response Emergency Act gets you out from under negotiating on impacts and effects as to these enumerated things that you might want to do, you know, hiring personnel, stuff like that. Nowhere in there is whether or not they need to negotiate over vaccinations. And then PERB seemed to say, apply the same reasoning here. So there's no need to negotiate over impacts and effects here. It seems questionable to me, not a correct reading of OLRCB, I think. So, but then the next paragraph is where it says, and under the CMPA, 61708A6 authorizes management. And then it kind of looks like it says to do what they want in an emergency.
Yeah.
Without regard. So long as it's not, one reading of this is it's not really particular to the COVID-19 Response Emergency Act. It's anytime an emergency has been declared. Then you've got the CMPA 0.08A6 that says you can forget about all this negotiation stuff. And if that's what PERB said, well, that seems wrong. It seems like we shouldn't let that stand. Do you think that's what PERB said? If so, do you think we should let that stand?
I don't think that's what PERB said. And if that is the interpretation, and I feel like we could reach common ground with the other side, which is shocking to me.
Yeah, I was wondering if we should just mediate this instead of having an argument. You guys might want to get around a table and figure it out.
So I think that the correct view of PERB's ruling, and the one that I take, is that the interpretation of the CMPA is in the context of a COVID emergency in which there is another statute that has the notwithstanding language. And that basically what the PERB saw the court is saying, and what the council was doing is saying, district, this is serious. You have to be able to respond to this emergency, and we've given you a freer hand than ordinary. So if there was a hurricane or there was a response by the district, there wouldn't be the same notwithstanding language in that emergency. And I think that a ruling by this court confining PERB's decision to the facts in this case and these circumstances would be appropriate, because I think that's what PERB was doing in the first place.
And something along the lines of, to the extent that this under the CMPA provision could be read as AFG seems to read it, that in any emergency, there would be no need to negotiate over impacts and effects, then that we set that part of the opinion aside. We vacate that portion of the opinion, and then we might be close to the finish line in terms of where everybody agrees.
I think that's right, Your Honor, except that I wouldn't set the opinion. I think that it would just be providing a clarification of the interpretation of the opinion rather than setting a portion aside. I wouldn't be doing my job if I said that you should set a portion.
I said to the extent one might read it that way, we would set it aside. I take your point.
There might be another approach which has been discussed here. To the extent that PERB's decision might be misunderstood when a future emergency arises, maybe it will have bad effects or unintended effects. And Judge Deal has earlier referred to this Munsingware doctrine, where courts sometimes vacate the underlying opinion when the issue becomes moot. Does PERB have an objection to vacating this opinion?
PERB would object to vacating the opinion, because the opinion as it stands is important to the extent, as counsel for the district stated, that the decision, as far as it's a management right, if there's a vaccine requirement, that could come back, and you would want to kind of have that issue clarified. Now, with that said, if there's another vaccine requirement that comes and there's another emergency, we would expect different and additional language, and this issue would not be kind of mired in some of the ambiguity that we have seen.
Can I ask what is the precedential effect of one PERB opinion on a later PERB board? Is it roughly you can't can't discard it arbitrarily and capriciously. You need to justify if you're going to deviate from it. Can they just reconsider more willy-nilly what they said before? Yeah, we said that before, but we got it wrong. Like this court maybe sitting on bunk, or is it more like this court sitting as a division where we're stuck with whatever we said before?
It is more akin to this court sitting on bonk. They can revisit issues because there is just one board. So there's no higher structure within PERB to reconsider an opinion. So they do not set aside opinions, without reasoned, rational explanation. And that is the standard which they apply to those decisions. I think in this case, the decision here was a response to a Superior Court decision that, they PERB initially took a different position on this. And so, if this were to arise again without the notwithstanding language in the COVID Emergency Response Act, I would expect a different response by PERB because the cases would be entirely and eminently distinguishable. That, if there was another instance where this came up, I don't think that this case stands for in any emergency, there's no impact and effects bargaining. I think that this case stands for in this particular factual and legal context with this set of laws and Superior Court decisions in place, this is how we're coming down.
Do you think this opinion stands for the proposition in any future emergency that requires a vaccine? 1804 is controlling.
So I think that in any future emergency requiring a vaccine with a similar set of laws in place, I do think that there would be a management right. And so that's a separate question from whether or not any vaccine requirement is lawful under the other principles that have been laid out in other cases before the Superior Court. That just as a matter of a management right labor law question, I think that this case does stand for, so long as it is a reasonable response to whatever future pandemic may hold, that a vaccine requirement would be appropriate. And we've seen that the FLRA reached similar conclusions about having vaccine requirements in hospitals, for example, with a vulnerable population and the statute there has a very similar term as far as management rights in the case of emergencies concerned.
All right, unless there are further questions, I appreciate it, Mr. Simpson, and we will give Ms. Hutchinson a couple minutes of rebuttal.
Thank you, Your Honor.
Your Honor, I would like to note and direct the court's attention to the joint appendix, page 6, note 4 of PERB's opinion. And in that note 4, the PERB noted that the union did challenge the mayor's authority to implement this vaccine and said that the public emergency had expired, but that PERB disagreed with the union and said that it was a management right for the mayor to implement this vaccine. So it's not true that before PERB, there was not a challenge to the mayor's authority to implement this vaccine.
I think their point was more, there was not a challenge to her authority to implement the vaccine during the emergency. And there is an argument about how long that emergency went on for, but that's certainly not likely to recur.
No, the public emergency was ended by the mayor on July 25th, 2021. And the vaccine requirement, her order was issued August 10th.
I think there's some disagreement among the parties and perhaps the PERB as well about how long that emergency went on for.
Well, the emergency had ended. It was not in effect. And the additional issue about a vaccine is whether or not the mayor is authorized to issue a vaccination requirement for employees. We raised the National Federation of Independent Businesses decision, which says that, an employer cannot require employees to get vaccinated. That was part of the matters that were before PERB. Now, they did not rule
Yeah,
on that.
wasn't this all a negotiability matter in front of PERB? Why not, like the district suggested, that sounds like grounds for an independent civil suit. Why is that part and parcel of a PERB negotiability appeal, whether or not the mayor can authorize vaccination of public employees?
Well, that was one of the issues that was underlying this negotiability appeal, which PERB they did not discuss the union's positions in in deciding the negotiability appeal. They just said everything was non-negotiable and that the district had the right to implement the vaccination requirement unilaterally. I mean, if you did not review and this was one of the things that we raised at Superior Court, if you did not review the proposals, there was no way to have a determination about any of the proposals. It was a blanket decision that declared all of the proposals non-negotiable. So there was no way to go into whether or not those matters should have been properly being issued by the mayor or imposed upon the employees. But we did challenge the mayor's authority to issue it. I did want to make that point.
Thank you.
Thank you.
All right, the case will be submitted. Thank you, parties, for your arguments and briefs, and the court will stand adjourned.
All rise. This court is now adjourned.